Hi, Marissa. Good morning to you from the US.
Good evening to you.
I'm really excited to have you on board because we've been discussing you coming for SAHR's Reimagining Justice podcast. It's a podcast we created by human rights lawyers and defenders for human rights lawyers and defenders. And as a person who's just taken on some really interesting work in strategic litigation, you were just the right candidate to bring on. Without further ado, I would just love you to introduce yourself to the rest of the participants.
Sure. Well, thank you so much for having me. You know how much I'm really inspired by SAHR's mission, which is why I wanted to get involved, and I love our conversations. I'm an attorney based in Washington, D.C. at the moment, and I work in international criminal and human rights law. And for the past few years, I've been doing a lot of work on strategic litigation cases. And I have a pro bono practice advising different NGOs on strategic advocacy. And I joined SAHR's board earlier this year, and here we are.
Yes, exactly, Marissa. And when we got in touch through the Hedera Collective, we were working on the draft ICC policy on gender persecution as a crime against humanity, and it was our first touch point. And I'm really glad that it so turned out our relationship has grown into something that now you are part of the SAHR board.
Me too. Really, for anyone watching who is not that familiar with SAHR, fantastic network, and please look into what.
Yes, absolutely. We're always looking to connect with human rights defenders who are trying to end gender-based violence through litigation, law policy reform. It's through this that you meet people like Marissa and other peer experts in your field. Well, Marissa, thank you so much. As I been kind of talking to you about your work around strategic litigation, tuning in actually are human rights defenders from all places. I know Kenya, Nigeria, Yemen, Colombia. So we have just a diverse group who are tuning in today. Let's first set the stage. What is strategic litigation, if you could define that for us?
Yeah, I found it useful to explain what it is on paper and then also kind of how I conceptualize it through the lens of victim-centered justice. So sometimes there are cases that address broader systemic issues impacting those beyond the named parties in a case. And this can present an opportunity for litigation to have a positive impact beyond just those named parties and to promote greater interest, social change. And this could be through creating new legal precedent or reform through the judgment of a case, raising awareness, destigmatizing taboo issues, and even mobilizing social movements regardless of the outcome. And this sounds really great in practice, or sounds really great on paper, I should say, but in practice, we have to be really careful about how we use this as a tool. And I think, and I found through my work, that it's important that when phrases, especially legal verbiage, becomes trendy, like strategic litigation over the past few years, and used interchangeably with buzz terms like public interest litigation and impact litigation, we need to be really cognizant as lawyers that our roles and duties to our clients don't shift just because we're operating within a more expansive and kind of aspirational framework. So by this, I mean strategic litigation isn't something that happens when lawyers are in a room together and say, I want to reform this law. How can we find some victims, relevant victims to bring a case? Instead, it's appropriate to use strategic litigation when you understand a victim or victim community and meaningfully work with them to identify their harms, their needs, their perceptions of justice, and figuring out together the best path forward, like we really should in every case. Sometimes this will be litigation, sometimes not, but more often than not, it's multiple different complementary pathways at once. But we really need to highlight victims being actively part of this strategy, opposed to it happening to them. And just the last point on this, I would say the reason I'm bringing this up early on, and I think it's so important, is because in strategic litigation, there are often so many different types of actors involved, especially in these cases concerning mass victimization, not just the lawyers and victims, but NGOs, governments, universities, tech companies, even activists, all helping to build these cases together, which is fantastic, but just not losing sight of different, while there are different agendas that might be competing to inform strategy, victims need to guide it. And without that, we don't really have ethical or sustainable initiatives and bad strategy. So I think that's really important. And I would say that kind of reflects the practice of strategic litigation and how we should think about using it.
Thank you, Marissa. I'm glad that you started on the note of making that victim-centered. What does this mean in practice, like in terms of, I know we will be addressing the design and execution of a strategic litigation endeavor, but could you perhaps touch on a little bit what it means to be victim-centered perhaps in the planning stage of a strategic litigation?
Sure. I think a really great way to look at this is sexual and gender-based violence cases. There's so much at stake for victims when choosing to pursue litigation, regardless of whether they achieve the outcome that they want. There's a lot of political backlash. Potentially, we've seen increased persecution, re-victimization. And that's why it's important for cases, especially SGBV cases, sexual and gender-based violence, for those who might not know, we call it SGBV. It's important that we take those through the victim-centered approach, because oftentimes the harms to victims can be somewhat mitigated when they have agency throughout the litigation process. So I've worked on cases where direct victims and their families have been harassed and threatened because of them pursuing this type of litigation. And I believe it would be much harder for them if they weren't aware of these risks from the beginning, managing expectations and allowing them to have agency. I mean, it's not really allowing, it's how it should be, but allowing them to have agency and decision-making throughout the entire process. So in SGBV cases, we've seen how this agency can benefit victims really because they have an understanding of their harm better than anyone. Yeah. And they might be able to demand charges or the recognition of more novel harms in cases that lawyers who are farther removed probably can't pick up on or might not. So 2 examples that come to mind are in the context of universal jurisdiction cases against the Yazidi population in the context of the Yazidi genocide. So one of those cases is from June 2021, I believe. A German woman who was also an ISIS member was convicted by a German court for crimes against humanity against Yazidis in the context of the genocide. And the court found that she imprisoned and enslaved Yazidis, Yazidi women and girls who were kidnapped and sold to ISIS fighters. And also, I believe, aided and abetted her husband in sexual violence against these women and girls. And this was the first time a court ever handed down a conviction for religious and gender-based persecution in this context. And it's so significant because it was only made possible by the victim's participation from the beginning. And there's also another case within this context happening right now, a trial happening right now in the Netherlands against one of 12 Dutch ISIL members, female ISIL members who were repatriated to the Netherlands from Syria, accused of crimes against humanity against Yazidis in Iraq and Syria. And this one woman is charged with slavery as a crime against humanity for using a Yazidi woman as a slave. And this prosecution was only made possible by their participation from the beginning. And I think these cases are a great example of when a case might not necessarily start as strategic litigation, but have the potential to evolve into it. So these cases that really lead to monumental outcomes, even if not through their judgments, but through inspiring participation that is really vulnerable, it can open the door and help expand access to justice for similarly situated victims, which we know there are many in the Yazidi context. And then it can evolve into this larger effort for the Yazidi community, for example, depending on how civil society and the prosecutors choose to engage, meaning making sure that it's victim-centered. But I think these SGBV cases are just a great example of how the process might not always start as this complex strategic plan. Maybe it did. But there's an evolution as well that can happen.
Thank you, Marissa, for that. Also, what makes strategic litigation strategic? How is it different from other forms of litigation? I think lawyers in and out are constantly doing casework. What makes strategic litigation different or unique or an added value to the day-to-day court work that they're doing anyway?
Sure, it's a great question. Victim-centered justice should be at the core of any litigation, whether it's quote unquote strategic or not. But it's different in this approach to coming at an issue from different directions. So there doesn't just have to be a case happening in a court. It can be complemented by advocacy through the media, through interactions with lawmakers. And it's also an opportunity to build this multidisciplinary network supporting this, effort toward whatever issue is at the focus of the strategic litigation. So by that, I mean, it's important to get, civil society involved. Depending on the context, it could be really, the mission of the litigation could be really benefited by engaging with activists, by technical experts who can help with open source investigations, maybe a UN mechanism. So it's different in that sense of it really being a joint, robust advocacy effort in and out of the courtroom.
Thank you, Marissa. And would you say that one would, is it a precondition or a usual characteristic of strategic litigation cases that you have several victims as part of the suit, or that's not a precondition?
I think that's what people think of oftentimes when they think of strategic litigation. But I don't believe that it's a precondition. I think a lot of or prerequisite. I think a lot of the time it takes a case with a single victim to open up a conversation, to see that there's maybe a need for access to justice for other similarly situated victims. I think we can think about it more as, a way to start a conversation that needed to be started long ago, more so than us needing to see the harm in numbers.
Thank you, Marissa. We have some questions come in, so I think just trying to lean into some of the questions that they're asking. What are some examples of successful strategic litigation in the past, and what do you think were the factors that made them successful? I know some factors you really cannot control, but what combination of factors lean into making something successful?
Sure. I mean, there's so many examples in national and international contexts. I think the one I mentioned earlier in the German court, where we saw a first of its kind conviction with a really novel harm being recognized of religious and sexual persecution in the context of the Yazidi genocide. That was one individual in one case, and so successful because of providing an opportunity in a court for victims to participate. And that really lacks in, a lot of fora and a lot of courts, a lot of jurisdictions that don't have procedure allowing for meaningful participation. I think, I don't know if that answered your question. Maybe I missed part of it. So please let me know.
If there are other examples of strategic litigation in the past that has worked in favor of victims, either by elaborating on jurisprudence or resulting in law policy reform, raising an awareness over a situation.
So I think a great example is really a case that's happening now. And there's already been great success before we even have the judgment. And I think that's an important element to highlight about what success can mean in these cases. So I have had the wonderful opportunity to work with this organization, a human rights organization in Russia called Obede Info. And they do fantastic documentation work of human rights abuses by the Russian government against their own citizens. Currently, these fantastic lawyers are, primarily in exile across different European and Asian countries. But they do really fantastic work for anti-war protesters. So Russians who protest the war in Ukraine and are being persecuted for this, even though they're peacefully exercising their right to freedom of conscience, belief, expression, speech, assembly. And this small but really mighty organization has not only done documentation and providing legal aid to these individuals, but has submitted complaints to the Russian Constitutional Court. And these complaints look at, and this is very recent in the past few months, so people can find this online. It should hopefully come up pretty quickly. But these complaints specifically address an Article 23.3, I believe, of the Administrative Code in Russia that was enacted just maybe 2 weeks after the 2022 full-scale invasion of Ukraine.
Oh.
And the article makes it unlawful to criticize the armed forces and leads to various penalties. There's also a criminal component, a complementary criminal component. And they represent many of those who have been accused of discrediting the armed forces, even though it's a right under even the Russian Constitution and international human rights law. So in addition to these complaints, we've also worked on building up this multidisciplinary network, and we have an amicus brief that is being sent to the Russian Constitutional Court, written by, I believe there are 2 different ones, submitted by multiple human rights organizations, arguing the article's unlawfulness under international human rights law, and also a network of academics who specialize in Russian constitutional law, who are arguing that it's unlawful under, that the article is unlawful under Russia's own constitution. And this is an example of what I believe is a success, because in this case, we're not necessarily expecting this quite partial and non-independent judiciary to bring to order a judgment in our favor, not necessarily expecting success in legislative reform, but we are making sure that these political prisoners and people, citizens exercising their rights, know that the law is on their side, the international community is on their side. Creating a record of these efforts, and doing our duty as human rights defenders, as you're very familiar with. So it's an example of a success that hasn't ended yet, but it's because we have to be kind of flexible in how we view or define what success looks like.
Yeah, Marissa, I like that you mentioned about how do we define success, and I think from context to context, success would mean different things. When you're up against the Russian Constitutional Court on an issue where they're massively influenced on, the likelihood of getting the judgment is probably not how you would define success, but because it's a litigation for strategic reasons, the judgment is not what you're simply seeking for, but there's more to that, and so then you then develop your success milestones based on that. I wanted to also add, again, depending from jurisdiction to jurisdiction, I found what could amount to the successful preconditions for a strategic litigation is if, for example, the defendants, whether it's a state, non-state actor, or other stakeholders who may be implicated, if they are not dangerous or powerful individuals, because that could lead to reprisals and retaliation. A lot of SGBV cases, one of the factors that allow for litigation to happen to completion is if victims don't withdraw. And that goes back to your point. If the entire endeavor is not planned with their needs at the center, the rate of withdrawal for victims, even in a normal litigation, is very high. So what more for strategic litigation, which puts them at risk of certain things. So I would say that will also definitely adjust the rate of success. Coming back to victim centeredness, which is the first thing you addressed today, was access to holistic services during the process of litigation, and adjusting for their needs. Oftentimes, I find with such litigation, there are periods of time when that litigation, when you're close to date of trial, that's when defendants start to put pressure on victims, families of victims put pressure on victims. And then you've got to manage that well and prepare yourself to manage that well, to ensure that the objectives are met successfully in that sense. Having a judiciary that subscribes to the rule of law is a fantastic foundation. But in your case, you are not always litigating in a context where you have a judiciary that you can rely on for the orders you're seeking. And so I think that, comes back to what your other strategic objectives are in pursuing a litigation, correct?
Yeah, absolutely true. And I think it is important to look at other objectives aside from actually getting a judgment in your favor. I mean, one is just having a record of your arguments, and enhancing victims, I suppose, their empowerment. There's something to be said for, even if there's not a lot of hope for a positive outcome, giving victims and a victim community a space to express themselves. It's, from my experience, much more satisfying when you're doing it before a legitimate court, which can be incredibly frustrating and painful. But there is still something to be said for giving victims a space to at least go through the process, of course, managing their expectations. And even if you can develop jurisprudence through, helpful precedent through bringing these types of cases, you can still raise awareness about the issue. You can really impact societal reform even without a positive judgment. I think just starting conversations, the process of litigation can help destigmatize different taboos, which can be a real factor in reform, in kind of changing the minds of a whole society. So yeah, I mean, there are other objectives like those that exist, and the value of these objectives depends on the specific victims in a given case, or this is what I believe, and their perceptions of what justice looks like. So if to them, they would find it valuable to go through the process, and that could be empowering, then that's a great objective. If they think it's worth it to start the conversation publicly, raising awareness about different stigmas, then that's a positive objective. But that is really victim by victim, case by case.
Yeah, and I love that you mentioned this myriad of objectives. Just as you are describing these, my mind is just going back to the cases, and I'm trying to pinpoint in the cases that we've taken what were victims' objectives. And sometimes, if you're before a criminal court, yes, of course, the perpetrator is likely to be sentenced, but the sentence itself was not important as just the findings, so that they can then push the Ministry of so and so to then propose a policy or reform of regulation or bylaw in order to ensure that such an incident is not perpetrated again. Some victims were also use these, as you say, that they express themselves. And what I love about this work, even as lawyers, you learn when the victims articulate what they have experienced as a violation, you understand, you get to characterize the wrongness of an act that seems quite normal in society. And as SAHR, we were doing a lot of work around sexual and gender-based violence. Sexual harassment is often, for instance, conveyed through a form of paternal advice. For example, don't wear that pair of tight jeans, you might attract unnecessary attention. I'm advising as a father to you, Or it can come across as a compliment. You look wonderful, resplendent, today. And in a society that doesn't see these as sexual harassment of sorts, it never gets articulated in a case. But when victims can have the power to express that and inform lawyers who, many of us are also not trained on gender-based issues, and forms of gender-based violence continue to be revealed to us as a form of gender-based violence, then you can express to the judge. And then, as you say, it opens a conversation about all the different ways in the cases that I've taken, sexual harassment is manifested in the society. And then the record of arguments, when you then take the record of arguments and um, you know present them in a webinar, in a press release, in an event, these are all spaces for the arguments to then be proliferated, and I guess also set the norm for like you define what the key messaging is for the public conversation that happens outside the court. So I really like that you mentioned about keeping a record of arguments, of course, for legality reasons, to put the state, if the state is the defendant, to put the state on notice. And also in some of my cases, even if we never won, it stopped the rest. So when we pursue maybe a set of defendants who we feel we've got a case against, of course, sexual violence, and I'm talking about institutional ones, never isn't carried out by isolated individuals in their free private time. It's often a system that permits it to happen. But once we prosecute or we litigate those cases, even if we don't win, all of those other individuals who participate in the system refrains from keeping engaged in the system. So there's a prevention or deterring aspect that comes even if we don't secure a conviction. So I really like that you say to find out what the victim's objectives are, note it down, put it in writing, and think about how we can achieve those objectives. So I think that's a very beyond the legal, like I want to get an order from the court. I want to, get that. Yeah.
And I think your point about deterrence is also a really important one. It doesn't always work as well in certain places, but sometimes it really does, especially when there has been a culture of impunity for so long in a certain place. So I think that's a great point to include.
Yes. And Marissa, I think that I was also going to ask you. I mean, you were taking, the cases of the Yazidi survivors, and then this case against Russia, and I wanted to know, like, some of this work is like it's 5-10 years long, no? But I guess you also answered because it's not just the case outcome that's important to you, but all of the other strategic objectives that you wish to push forward.
Yeah, I would say it can still matter. I just want to make sure I'm touching on one other point on this. So it still matters as an attorney and in advising clients or potential clients, it's still really important to be selective and intentional about what cases to take on. Yes, I would say I don't take issue with taking on a case that I expect will lose in court if there are other really important objectives to be met that we believe can be met outside of just the courtroom judgment. But I do think it's important and take issue with weaponizing strategic litigation for purely political purposes.
Okay.
And by that, I mean, it's important that we uphold the legitimacy and credibility of this approach, this form of litigation. And it's really important to act in good faith. And that means and this is just personal beliefs, it's okay to bring a case that you don't expect will win, but it's still important to respect the resources and the time of a court. So we still don't want to do that as long as we, or if we don't have, the evidence to support the case. So I guess by this I mean, if we're working in a corrupt judicial system or where the rule of law is really weak, that's one thing. But if we're not, and we don't have a strong case, and we're just kind of throwing, options at a court, or different weak arguments at a court, I think it's important that we remember strategic litigation is still litigation. We have to act in good faith, and ethically. So there's a line there, if that makes sense.
No, absolutely. I think one of the questions brought up by Irfan Hussein Babak was also kind of what are the ethical considerations that lawyers must take into account of. Do you want to touch on that a bit more?
Yeah, I think it's a fantastic question. I'm glad this person asked it. And it comes back to treating strategic litigation like any other case in terms of our obligations to our clients, our obligations to the court, and really the same exact ethical standards, I believe, as any more traditional case. So, like I said, if you are working within a corrupt judicial system where the rule of law is weak, and you think you have a really strong case, and the evidence is there, there's absolutely no problem, in my opinion, to bring that case, as long as you are managing your client's expectations, having transparent communications, and are possibly meeting these other objectives, or in good faith working toward these other objectives that we talked about. But it's important to, like I said, for the sake of credibility and legitimacy of strategic litigation, we don't want this approach, this tool of strategic litigation to turn into something that lawyers use to just push political or personal agendas. So I would look at it through the lens of any other case.
Yeah, excellent. I think the risk analysis in terms of whether or not you could win the case and then taking yourself through that process is very essential. One question came about using strategic litigation to advance social justice. Can I have you answer that question kind of just in relation to social justice is more than just the legal justice. It requires you to work with the actors in society. Tell me more about how you can use strategic litigation in collaboration with other actors. Who are they? What value they add? What inputs do they give in order to achieve, social justice outcomes in that regard?
Yeah, great question. We know that strategic litigation, the core of it is victims and civil society, and that always has to be there. But to maximize our strategy, we really need to build and call on, multidisciplinary experts and partnerships in ways that can serve our clients and victims' aspirational goals and perceptions of justice. So that's part of the analysis, as we said, figuring out, working closely with victims, what their perceptions of justice are. So this allows us to tap into a pool of resources and really be mobilized by this complementary expertise. So in the Russia context, as I mentioned, the effort of Obide Info and these different groups of experts submitting amicus briefs to the Russian Constitutional Court, that's an example of tapping into different types of expertise that can really enhance the case that's being brought. And the perspectives of the complaint. So I think it might be helpful if I briefly explain the amicus curiae brief process, because this is an opportunity for so many different types of partners to support a case. In most jurisdictions, they can be written by almost anyone, any individual or group who might be able to offer expertise or insight in offering assistance to a court in making its decision. It depends on the jurisdiction, if the procedure of a jurisdiction, whether you can just file with the court system or if you have to file a request for leave of court, so permission to file. But it's a really great way for more voices and expertise to be heard on an issue. So in the context of Russia, we're working with academic experts, international human rights experts, and these fantastic Russian lawyers who are, and civil society, who are really at the core of the issue being addressed. And on top of that, in the Russia context, we have media and public awareness campaigns through a webinar and op-eds, and getting the message across to different audiences. We have the court, we have lawyers through this webinar, through the International Bar Association, and then the general public through an op-ed. So this Russia case is a great example of mobilizing completely different types of expertise. There can also be a lot of challenges in cases of mass victimization, where there is collective and individual trauma, because there can be diverging perceptions of justice and preferences for what strategy to take. So another example that I think is helpful to touch on, looking at different types of partnerships and collaboration, is the Islamic Republic of Iran. So for the past few years, I've been working on strategic litigation in US court through an exception to a US statute called the Foreign Sovereign Immunities Act, the FSIA, where there's a terrorism exception that allows US citizens US plaintiffs to bring a case against the Islamic Republic of Iran, or I should say, against any country that is listed as a state sponsor of terrorism by the US State Department. So it's kind of an exception to sovereignty in very limited circumstances. So Iran is on that list, that quite short list of countries. And through this terrorism exception, US citizens can sue the government of the IRI, of the Islamic Republic, for limited violations, including torture, hostage taking, extrajudicial killing, and aircraft sabotage. And this is a really interesting example of where it's important to work with civil society due to the mass victimization nature of the issues. But it's challenging because there are a lot of diverging views, disagreeing what justice should look like. Some people don't think we should go through a US court. But in this case, it's really one of the only options for any type of redress. In this case, civil case. So it would be monetary damages, monetary reparation. But I'm not Iranian, I'm not an expert on Iran, but through the lens of me working on these cases and these clients and civil society, there are many diverging viewpoints about how to achieve justice for the many violations carried out by the Iranian regime, and how the regime should be reformed. So it's an example of, these cases, they're normally 1, 2, 3 plaintiffs operating within this larger framework and this much larger civil society where thousands and thousands of other people have been similarly violated.
Mm-hmm.
So while being informed by civil society, by different subject matter experts who can really build up your case, you really still need to be led by your client. And that is really at the core.
Mm-hmm.
So from my experience with these cases, about 8 or 9 of them, every client is different, but they generally hope for the cases to bring public awareness, acknowledgement of their suffering by a legitimate court, and as you pointed to earlier, to deterrence. So that's a commonality, but it's important to be aware that while we want to utilize partnerships and different types of expertise, it's our job as lawyers to be guided by the client we have agreed to represent,
Mm-hmm.
and not necessarily civil society as a whole, which can be very challenging.
Yeah, and that brings it back to like the survivors' main objectives. I even remember once we had a case. Survivor had no interest in her boss, who had committed different forms of sexually coercive acts against her. Had no interest in having him be imprisoned, but she just wanted her job back. We also have a SAHR fellow, where even all of the plaintiffs in the case wanted to be restored their positions, livelihood being the most important aspect of the end goal of it. And in such cases, you work with the different strategies, and maybe sometimes you want to build a case in order to then carefully warn the opposing party that, if you don't settle with what the client's demands are out of court, then this could escalate into something more that has more serious consequences on you. And that's why building the documentation of evidence is so important, because then with that you can channel your case to whichever avenue you would like to push for. And I also wanted to add, in terms of advancing social justice is what the survivors want. Not all of the work needs to be like public advocacy.
Mm-hmm.
In fact, once you've developed the basic evidence of a case, and there were cases that we knew, okay, we are never going to reach the evidentiary threshold of rape, for example, because it's so hard. But we nonetheless pursued the case, and then in the back door, we just started to discuss barriers to justice. For instance, the statutory limitation period was just too short for some of the survivors who were harmed when they were children to then bring forth, within the 10-year limitation period. So because we have compiled the evidence, we then opened a conversation with the Ministry of Justice to lengthen to start thinking about reforms to criminal procedure, knowing that we wouldn't succeed, we may not succeed in the criminal case, but that the survivors' interest in even bringing it forth was to make sure that other women or other girls in the case that I'm referring to would also. So I think closed door meetings with government authorities who you can more or less trust, and even having a public facing strategy, and then the private facing strategy might take, and working it out smartly could be really very, very helpful. We have a few more questions that have come in, and I will, Marissa, if you don't mind, slightly extend our podcast time. I'm going to address just one more question with you in terms of how do you plan and design a strategic litigation, like just in terms of the practical steps. Then I want to bring in two people who would like to address question directly to you. I just wanted to also note that we have a question in the chat that I will also link to a question that we will raise to you later. So just to wrap up like this section of the podcast, uh, tell us more about how you would go about practically in terms of designing and planning a strategic litigation.
Sure. So toward the beginning of the process, there are a few questions that are important to ask. It doesn't have to be yes to all of them, but I think it's a great way to start thinking about, hey, is this the right approach? Is this the right case for this type of, or the right tool for this type of case? The first is, do the alleged violations reflect a systemic issue? Is there a broader impact needed here? The second is this case solid enough in terms of evidence? This comes back to what we're talking about in terms of, can we bring this case in good faith? It's an important question and reflection on ethics to ask in a more traditional case, but also here in strategic litigation. And the third that gets at the theme of this conversation that I think is really important is, do the circumstances of the case and the procedures of the fora, the courts that are feasible to bring the case, can they hear the case and also support a victim-centered approach in the process where victims can meaningfully participate? So, for example, in the Russia context that I've been talking about, it's a great example because there's a lot of back and forth about if and how to pursue litigation due to the unlikelihood of success, given the state of the Russian judiciary. But if you look at these three questions, it meets two of the three. The issues of persecution of peaceful anti-war protesters reflects a systemic issue. These cases are definitely solid in terms of evidence. We can bring them in good faith. But the forum, the court system, doesn't support a victim-centered approach where victims can meaningfully participate, because even if they can, they're not really going to be heard impartially and independently. So this is an example of, okay, maybe it doesn't meet all three of these boxes, but okay, we can still provide these victims meaningful participation in other ways in achieving other objectives. So I would say those are the kind of starting questions. And then a huge part of the strategic litigation planning and designing is where to bring the case. There are a lot of considerations, but sometimes the forum is decided for you. For example, in the context with my cases against Iran, there are not a lot of options to choose from. You have to be quite strategic in finding the exception in that one statute in a different jurisdiction from where the harm actually occurred. So some considerations for if you have the luxury of options, you can ask yourself, where is the case, where is it more advantageous to bring the case? So if the claims are being brought against a state, sometimes bringing the case in that state can risk severe bias. So if you have the luxury, you can consider pursuing the case in a different state, maybe under universal jurisdiction laws. Because universal jurisdiction is an avenue that is becoming more accessible for those who can't seek justice in the jurisdiction where the harm occurred. And in recent years, in places like Germany and Netherlands, as discussed in the Yazidi context, it's really becoming a great option, a great second option, or first option because the original isn't feasible. Another question to ask, can victims participate in this forum? As mentioned in those kind of initial questions to ask ourselves. Maybe if there's a truth commission available or a human rights commission that is available for a given issue or topic, like subject matter, maybe that is more feasible than a court, or more effective than going through a court system. Another question, what risks might the victim face? And can those risks be mitigated? Is it worth bringing this case in the same state or region where the harms occurred, and the relevant stigma based on that context is so strong? Is it worth it? And that comes from conversations with the victims as well, and what they are willing to handle.
Yeah.
And there's really no judgment either way.
Yeah.
A few more questions that I would ask are, do I need to exhaust remedies before bringing a case before a particular court? So sometimes, for example, looking at the ICC, the International Criminal Court, that's just one of many examples. Sometimes you have to exhaust remedies, all of your possible remedies, before being able to even get to a certain court or tribunal. So it's important to be aware of that strategy, and being able to be a bit forward thinking as well.
Yeah, very good.
Also asking, is it feasible to pursue multiple fora at once? Should I be submitting something to a submission to the UN Working Group on Arbitrary Detention at the same time that I'm bringing a case through a universal jurisdiction law in Germany? So I think it's important to think about those simultaneous avenues as well. And then one other question I think is really important in choosing a forum, or I guess maybe after choosing a forum, or it depends on what laws are in a given forum, what laws allow you to bring a case, criminal versus civil. So should I be bringing this case, case as a criminal case or as a civil case? And I don't think I explained it well, but what I meant trying to get to this point was, in the US, in the context of these cases against Iran, the civil avenues are more readily available and match a lot better with the goals of the victims than criminal avenues. So if you don't have the luxury, where in these cases we don't, civil is really the only option. But if you do, there are different considerations to take. Criminal, it's often more high profile, which sometimes means greater impact, sometimes it doesn't. The burden of proof is higher, so penalties will be higher. And many scholars argue that leads to a greater deterrence effect. Where in a civil case, those points aren't true, but victims, plaintiffs, clients might be able to have more control over the proceedings and pursuing their claims, might be able to be more involved because they're not just labeled as a victim in a criminal case, but actually a named party. And lower standards of proof, which might make the process more accessible. Yeah. So to explain this a bit better, the other questions are great questions to ask in deciding what forum. But once you have a forum, once you've chosen a court, you have to figure out what type of case is feasible to bring based on the laws of that jurisdiction.
Thank you so much, Marissa. I think that's really very helpful how you've kind of listed the questions. And if anyone is taking on a strategic litigation case and just want to do a brainstorming session with SAHR team and our network of peer experts, we're really happy to organize that. Just please get in touch with me directly by email. We have a human rights lawyer by the name of Precious from Nigeria who has a question for you, as well as a human rights lawyer from Colombia. Her name is Catalina. I'm going to be bringing on Precious onto the stream so that she can engage. I think she may be having some sort of difficulty connecting, so I'm going to bring on board Catalina to address her question.
Yes, thank you, Natasha, and thank you, Marissa. I would like to ask if there or could we think about building a toolkit applicable to all countries for human rights defenders to do a strategic litigation in different national contexts? And how can we connect this to international litigation? Thank you.
Thank you, Catalina. I think those are really great questions. Natasha, do you want me to go ahead or wait until all the questions were asked? Oh, I think you're muted. Sorry.
Hi, Precious. You can also go ahead with your question, and then Marissa can reply to them both. Thank you. Precious, you can go ahead with your question.
Hello, can you hear me? Good afternoon.
Good afternoon.
All right. So, yeah. Okay. So, Women's Rights and Health Project is an NGO in Nigeria, Lagos, Nigeria, to that works against sexual and gender-based violence. And over the years, we have had 741 cases of SGBV, and 45 of these cases have been charged to court. Now, these cases have different dynamics and all that. But the major question that I want to ask is on a case of an 11-year-old girl that was started handling in the year 2020. She was gang raped and then she died. Now we have filed this case in court. The police, the answer that we were told from the court was that the police did not bring the evidences, the forensic evidences, although they conducted scan, they conducted fingerprints on the girl. The forensic evidences was also carried out. But while the police was duplicating this case file to the Office of the Public Defender, they removed these evidences. So the Office of Public Defender could not give an advice that is holding these perpetrators to continue on this case. So based on the advice, those perpetrators were released. After we find out that they were released, we filed another case against the police, against the Ministry of Justice, against those bodies, telling them that how can they release? Everybody saw this case. Everybody were witnesses to this case of this young girl that died. How can you do such a thing? We've not been able to get judgment for so long. Then last month we got a call that we should go back and refile this case for mandamont, compelling the police to forward those evidences, those documents to the director of DPP for a proper. Can you still hear me? Am I still on the call? You can hear me. So in Nigeria, there's a lot of cases like this that have gone.
I think she's
Knowledge.
unfortunately having connection difficulties. Precious,
Yes.
we've got your question.
Okay.
We've got
So using your wealth of knowledge, Marissa, can you tell us what exactly that we will be doing in ensuring that this case gets justice?
Thank you, Precious. Natasha, if you don't mind, I'll answer Precious's question, and then we'll go to Catalina's. So I'm very sorry to hear about this case. It sounds like you're doing really fantastic work, and I appreciate you bringing up this question. I'm not familiar with Nigerian law and practice, so I'm not able to provide too much advice without doing more research, and I'm really happy to speak offline. But my initial thoughts are this sounds like it has been an incredibly frustrating process with the courts. It might be best to proceed and exhaust all remedies within the court system to build a record with the court system, and then consider what other avenues you might want to take. This will depend on, I assume it's the girl's family who is really driving this case. So it will depend on what her family wants out of the case. As we've been talking about what justice looks like for them. Is it more about the perpetrators? Is it about other types of reparation? Is it about reform within the police department? And then looking at what other domestic or regional human rights commissions that are available, and have jurisdiction, if it's worth taking that route. But again, I'm really sorry to hear about this. Your work is appreciated, and I'm happy to speak more offline about specifics. I don't know if someone else might have a bit more specific, useful help.
Yeah, I think the only thing I would add, so mandamus, I mean, for those who don't come from a commonwealth, the jurisdiction, is a form of judicial remedy. So it's a remedy, a court ordering a competent government authority to take a specific action that's obligated to do. The fact that you've received a mandamus is in itself, I mean, it is a judicial remedy. It's an acknowledgement that the police didn't take certain actions that it was obliged to do. My only, as Marissa was saying, you've got to then exhaust this. I mean, this mandamus that has been presented, issued by the court, I'm sure you will have got to follow it through to completion. I think what may be interesting as you follow through that to completion is to start documenting from the time the police was obliged to hand over the relevant evidence, to start documenting what violations were then committed by omission by the state of your province, or I think it was Lagos you were mentioning, and characterize it as a state accountability issue. So going beyond the primary violation that was committed against your client, what secondary violations were committed by the state from the date that evidence was withheld to the date of the order and continuing. I think that will frame the impact of withholding or failing to present evidence to the prosecution on time, and it will capture that, because I'm very sure that such omissions by the police is common. And once you're able to articulate that impact on the families, I think you are able to also characterize the violation in other terms. As Marissa said, we're really happy to discuss this further in offline if needed. But it seems like you've been taking all the right steps. I pass the question, Catalina's question, to you, Marissa.
Yes. So thank you again for your questions. In regard to the question about building a toolkit for human rights defenders to rely on for strategic litigation and different national contexts, there are a lot of resources out there already by the UN, different UN agencies and human rights NGOs, which I'm happy to share offline. But it really is a fantastic idea to continue to have dialogue informed by lessons learned in strategic litigation cases on how to maximize planning, designing, carrying out strategic litigation, especially as universal jurisdiction cases are increasing and being relied on more. I think would definitely be helpful to have a regularly updated toolkit to support this work, and really quite detailed for different jurisdictions. And maybe there are, these other resources that are already available can be a starting point for that. In terms of connecting this conversation to international litigation, strategic litigation is equally prevalent in the national and international context. And they really operate quite similarly, really on different scales and relying on different law. Sometimes national, strategic litigation in the national context has to be exhausted before reaching different venues in the international context when we're looking at issues that have a crossover with violations under national and international law. But an interesting place where we see this overlap in cases is, where cases are brought under universal jurisdiction. So I think that universal jurisdiction will continue to be a really useful resource, although it is controversial in some circles, understandably. I hope that answers your questions.
Yes, thank you very much.
Yeah, and I'll only add to that there are several national avenues, legal and non-legal, and then there are other international avenues, legal and non-legal, some diplomatic, some political, and some that's more to do with media, some that's more to do with advocacy. So I think you think about this in terms of your toolbox. Like I have a case, I have an issue that I need to address. I'm going at this point in time under national jurisdiction, I have this pathway. So I'm going to go down this pathway. Oftentimes you don't know what the outcomes may be. But along the pathway, I anticipate I'm going to face the following challenges. So now I'm going to open my toolbox and think about what I can use nationally and then what I can use internationally. And when do I use them? It may be that doing a media uproar, it's not timely now. You may want to wait for a strategic event. You want to make it coincide with, International Women's Day. You might want to coincide with 16 Days of Activism. You may want to coincide with an important delegation visiting your country. You may want to think about this in terms of timing when to use the toolbox. And sometimes certain, as Marissa says, sometimes the jurisdictions is already set in stone for you. So then if you know that the legal options is set in stone, you don't trust that it's going to help you meet your objectives, then look at other non-legal venues and see if you can still meet those objectives outside the jurisdictions that you've got to navigate your issue in. So like Marissa says, and if I may say, SAHR was designed exactly for this. Like Marissa and I, we were discussing a couple of days ago that, Marissa is a really highly qualified lawyer, but she says, I still feel I'm thrown in the deep end of things. I still have to figure things out. And we're in a time of our lives where we, as women or as LGBTQI persons, we are swimming in the dark, finding possible legal solutions that may or may not exist. Then it may be a litigation or a policy or law reform opportunity. And so the SAHR network is really, this podcast is just for me to introduce Marissa to you and to just open this discussion up. But the real discussions can happen closed door. We can have meetings to discuss specific cases that you're taking, specific issues you're handling, and start to untangle issues, as well as put forward a roadmap or a vision of all the tools you have in your toolbox, and then bringing in the expertise I mean, Marissa has experience in international criminal law, universal jurisdiction in Europe and the States. Catalina will have something else. Precious would have a toolbox. I think she's doing incredible work in the national criminal courts in Nigeria. So we each have tried different tools in the toolbox. And I think when we can all circulate our ideas of the tools that have been useful, that's when the roadmap can kind of be fine-tuned for your case based on your needs. And so, Marissa, if I may trouble you further with the last question. Now, this question I have to ask you because it comes from a women rights lawyer that Catalina and I met recently. She's from Yemen, and her question is quite similar to Richard's question in the chat, and it relates to the International Criminal Court. Specifically, what is the place of strategic litigation at the International Criminal Court? How can one use it, or what are its barriers of accessing it? Could you perhaps comment on that as a final wrap-up question? Thank you.
Of course. So the International Criminal Court is an entirely separate podcast, but it is definitely relevant for this conversation. It primarily requires the exhaustion of remedies before getting there. But there are different ways that a case can be referred to the court. So while the exhaustion of remedies in national jurisdictions is normally a prerequisite, sometimes cases can get there because a state is unwilling or unable to prosecute certain perpetrators within their own court system. In some instances, the UN Security Council might refer a case to the court, which can actually bypass a handful of requirements we've seen in the Darfur and Libya situations before the court. And as Natasha can probably speak to more in the Afghanistan context, the question of willing and able is really important. And sometimes the court's decision on that question is the game changer. I would say, in terms of what role the court can play in strategic litigation, the most tangible avenue that comes to mind are Article 15 communications, Article 15 under the Rome Statute. And these, what we call Article 15 communications, mean that submissions can be sent to the Office of the Prosecutor of the International Criminal Court to bring to their attention different cases or different issues that the submitters believe the prosecutor's office should know in pursuing a case, in hopefully pursuing a case to support a case that's already open. So I think Article 15 communications are a great place for those who are in the world of strategic litigation to do research into and to see if it might help them to utilize that tool in communicating with the Office of the Prosecutor. It's a pretty unique but really important option out there. And of course, the prosecutor's office allows enables other more informal communications. If, for example, someone has specific information relating to a case or wants to participate as a victim, direct or indirect, there's this whole infrastructure in place at the court for the participation of victims. So there's a lot to utilize there. that can support strategic litigation efforts. So those are the main avenues and tools through the ICC that come to mind for strategic litigation. And I've seen it, in my own work. And I think the victim participation procedure at the court is imperfect, but it is really a really robust start. And there are constant conversations about adapting it, building it, improving the procedure in place. But it's a really, really great starting point that we haven't seen in really before. So.
Yes, thank you very much. And I just would like to add that something that Marissa, our team, and a team of other human rights defenders worked on was the ICC draft policy on gender persecution. It, of course, relates to international crimes, but I think that whole concept of gender persecution is interesting even for national contexts. If you're in conflict or post-conflict zones and your country has adopted the Rome Statute or has adopted a variant of the definition of gender persecution, I think it's really interesting to read their draft policy. It's just recently published, and it's only by us, applying it in the context that we face, even if it means experimenting with things for now. It's the only way we can develop jurisprudence and also push the justice system to acknowledge wrongs that have been normalized for a very long time.
Absolutely. So that brings to a kind of a final point. Take advantage of when these courts, tribunals, organizations open up the communication pathways and say, hey, this is our draft policy. And we want to hear from civil society, from your direct experience. What do you think about this? What could we improve? What are we missing? So it's so important to take advantage when those doors are opened, and also to try to open those doors when they're not.
Very good.
And SAHR does that all the time.
Well, Marissa, this was really an interesting conversation. Like I said earlier, I think you have embraced some of the biggest human rights challenges that the world is facing today. And I think as you experiment and navigate that, you will continue to document those lessons that you've learned, your own reflections, both personally and professionally. And I hope that you can bring this into more conversations with SAHR and our network of human rights defenders from all over the world, and that we can be a resource for each other.
Absolutely. And SAHR is really the prime example of this work in action. So thank you for being so open and being a resource for so many. And I'm really excited for all the work that we'll do together.
Same here as well. Marissa, I wish you a great day ahead, and I wish for everyone who's tuned in, thank you very much for your participation, your excellent questions. I'm sure this is a conversation we'll continuously have in the future.
Yeah.
Have a good one.
You too.
Bye.